We at Searcy Denney have been working on various forms of the transvaginal mesh litigation for several years now, and so it's time to give you sort of an update. I was personally appointed by Judge Clay Land to be a co-lead counsel in the Mentor Obtape MDL, which is pending in Columbus, Georgia. It's probably one of the older transvaginal mesh MDLs in the country. And I'm pleased to announce that right now, along with 3 other firms, we have settled all of our cases in the Mentor Obtape litigation. We're very pleased with the settlement. We believe our clients are as well. But one of the things that we learned in negotiating the Mentor Obtape cases, which could give us some information about what might be happening on a national level with the 55,000 other vaginal mesh cases that are pending around the country right now, is basically that the challenges we face are really threefold. One, there are an awful lot of what we call product in place cases filed. That means a woman was implanted with some form of a vaginal mesh product, but the woman has only had as a complication potential pain. There has never been a surgical procedure to address any complication associated with the woman's implantation of vaginal mesh. Those are cases we basically call product in place. The product that they're alleging is defective in the lawsuit is still in the woman's body. Companies invariably take the position that those are cases that they do not want to pay compensation on, and they're very adamant about that. It's really hard to argue against that from the plaintiff's side. It's unmoving to the neutral third parties that help us negotiate these cases, typically special masters, arbitrators, or mediators, because it's just fraught with the possibility for fraud. It's way too easy for a woman to say she's in pain. There can be, even if a woman is legitimately in pain, there can be a lot of reasons for her pain that are unrelated to the vaginal mesh product. So unless a woman has actually had a surgical procedure to address a mesh complication, those product in place cases are very, very problematic. The reason, in addition to those reasons that they're problematic, is there's a lot of those cases filed. And so when you sit down with the defendant to talk about potentially resolving a large group of cases, invariably the discussion goes right to what are we going to do with these, hundreds or thousands of product in place cases. Right. The second issue to be addressed in these cases that is very complicating is the fact that many, many women had multiple mesh products manufactured by multiple defendants implanted in them either at the same time or consecutively as the result of complications with earlier mesh. We've seen this time and again. A woman has a stress urinary incontinence product that's at issue in some of these cases. There are lawsuits filed over that product. Also has a pelvic organ prolapse product implanted essentially at the same time, or it's in place in the woman at the same time. It is very difficult in those cases to say which one of those products is causing the woman's problem, even if she's having legitimate problems. Not just product in place, but erosions, infections, migrations of the product. It's very difficult to parse out what those complications are related to and which product. So in those circumstances, it's very difficult to address those cases with the defendant in terms of resolution. And the court even struggles with that. What do you do? Which MDL do you put those cases in where the patient has multiple products that actually could be in multiple MDLs? So the final problem that we're dealing with in the vaginal mesh litigation is the sheer number of cases that are filed right now. As I mentioned earlier, I believe the MDL judge that has 4 MDLs, the major MDLs before him up in West Virginia, now has about 55,000 cases filed. Just taking on even the concept of trying to negotiate a settlement for that kind of number is very, very problematic. But the good news is there seems to be some significant momentum towards resolution of these cases. Bellwether cases have been tried. It doesn't make a whole lot of sense at the top levels at the MDL to try more bellwether cases because the parties now have a good idea of what those trials look like and what the results can be. That generally is a prerequisite to initiating discussions towards resolution. In addition to that, sheer time is on our side. People get frustrated with the lack of progress in the litigation. Not only the court frustrated with the lack of progress in the litigation, but the parties, both sides. It's significantly expensive, tremendously expensive, to have ongoing contentious litigation. So the time, the expense, the aggravation probably is mitigating towards what we see as these cases ripe for resolution. We are still taking vaginal mesh cases. We are limiting our intake to those cases where the plaintiff has actually had a surgical procedure to address a mesh complication. Most likely, what we would like to see is those cases where the patient has actually had vaginal mesh removed from their bodies. If you have a case where you've had a serious complication with a vaginal mesh product, you've had a surgical procedure to address that problem, we'd be happy to consult with you as to whether or not you would be an appropriate candidate for a case.